Parliamentary sovereignty. According to A.V. Dicey 1885, sovereignty, that is, ultimate power, lies with Parliament. Dicey outlined the main features of parliamentary sovereignty as 1. Parliament can make any law it wishes, omnicompetence. 2. Parliament cannot bind future parliaments. 3. The courts must apply the laws made by Parliament. 4. Laws made by Parliament override all other forms of law. Parliament is omnicompetent, meaning it is all-powerful and has the authority to legislate on any matter. This can be seen in its ability to make laws which affect the monarch. For example, the Act of Settlement 1700, which prevented the children of King James II from succeeding the throne. Furthermore, the Crown Act 2013 changed the law on succession to the crown so that females had the right to become queen if they were born first. Parliament can also change its own powers. This was seen in the Parliament Acts of 1911 and 1949, which allowed the House of Commons to introduce laws without the approval of the House of Lords. Parliament can even pass laws that are incompatible with the European Convention on Human Rights. The minister responsible for introducing a bill must make a declaration as to whether, in their opinion, the bill is compatible with convention rights. If they believe it is compatible, the declaration is made under Section 19(1)(a) of the Human Rights Act 1998. If they believe it is incompatible, the declaration is made under Section 19(1)(b). A declaration of incompatibility will not prevent the bill becoming law. The first declaration under Section 19(1)(b) was made in the Communications Data Bill 2012 in relation to a proposed ban on political advertising. The bill never became law as it did not have the support of the Liberal Democrat members of the coalition. Each new parliament must be free to introduce or repeal whatever law it wishes. The only constraint is MPs need to appease the public if they wish to be re-elected. The courts have to apply the laws made by Parliament. This applies even if the law infringes the European Convention on Human Rights. The courts can make a declaration of incompatibility, but they must still apply the statute. This was seen in HV Mental Health Review Tribunal, 2001, where the Mental Health Act 1983 placed the burden of proof on the patient. There is no power to challenge the validity of an act where the correct procedures have been followed. In British Railways Board v Picken, 1974, Mr. Picken was deprived of his land under the British Railways Act 1968. He argued that British Railways Board had concealed matters from Parliament during the progress of the bill, which amounted to fraud, and that the act should therefore be struck down. The court held that they had no jurisdiction to invalidate an act of Parliament. Statute law is the highest form of English law. It is binding and will prevail over case law, regulations, bylaws and the European Convention on Human Rights. The case of DPP v Smith was reversed by statute with regards to the meaning of oblique intent by Section 8 of the Criminal Justice Act 1967. In summary, parliamentary sovereignty relates to Parliament having ultimate power. It consists of four main principles: that Parliament can make any law it wishes, it can't bind future parliaments, the courts must apply the laws made by Parliament, and laws made by Parliament override all other forms of law. Please see separate video for a consideration of the restraints on parliamentary sovereignty and its relationship with Europe. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.